very much for inviting me, Jill. It's been it's a great honour, and it's kind of ironic, as I say. I've had the privilege of working at Eurojust for almost 4.5 years now, and I just to preface what I say is that I'm not an academic, although I did do a little bit of teaching in medical law one time, but I'm not an academic in this field, so I'm very conscious there's a lot of expertise out there, in particular within the institute here, and there's some very good literature that's come from this institute in this field as well. So I'm coming from the perspective of a practical prosecutor. I think to date with these types of instruments, I suppose the value that we give is that as practical prosecutors, we give a human contact. We're a human contact point, and I suppose part of the challenge is that if there is a necessity to deal with a blockage or a problem, a delay, misunderstanding, we are attempting to give that added value over and above the normal mutual legal assistance. We couldn't possibly, and Eurojust, it's quite a small agency by agency standards. There's no way it could deal with thousands of requests. It would make no sense to try and replicate a well-defined system that's already there in terms of mutual legal assistance between all the various states. But having said all that, it started back in 2002 when they moved to The Hague. There were, I think, maybe 300 cases that were actually formally registered. We have a registration system, and we're now up to, I think, last year it was just under 1,200 cases. At least 600 of them were quite complex cases involving more than 2 countries. But one key area, which is an indication of the potential with this warrant, is the European Arrest Warrant. And difficulties associated with the European Arrest Warrant. And quite a number of the cases were issued, we've had experience in all the member states with difficulties of varying types. Some of them quite practical issues of translation, issues of even things like questions about the costs of escorting persons when a surrender is done from one place to another, when the order is made. Competing warrants is an emerging development. France wants a person, Germany wants a person, but also Portugal wants the person. And whilst there's well-defined rules within the framework decision for the European Arrest Warrant, even notwithstanding that, there's an element of uncertainty. And again, where Eurojust can give some assistance where there are blockages is people we can organise, we can sit down with the relevant parties, representatives of the member states who are dealing with the case, to try and come to a workable solution as to where the person should go, rather than necessarily having to rely completely on the judicial authority who physically has the person to make the decision. That we can give some assistance. And in fact, in the legislation, the European Arrest Warrant, there's a possibility in all the national legislation of a court which has to make such a determination on things like conflicts that they can ask Eurojust if they wish. There's been, I suppose the big advantage of, well, some would say the advantage of framework decisions in the third pillar as opposed to conventions, although there's a lot of discussion and argument about this, is that because of the way conventions take time to be actually implemented by the signatory states, it does take quite a long time. And I think, for example, the 2000 Convention and the protocols, when they were fully implemented finally implemented in our legislation in 2008, there are still some member states, I think, there are still some aspects of that convention that are outstanding. Whereas with a framework decision, at least you have, when it's negotiated, you have an implementing date, and certainly pre-Lisbon, you have the whole process of evaluation, peer evaluation, and that's gone on with the European Arrest Warrant. And I might make some comments about that later, just in the context of what could come up with the European Evidence Warrant. Now, this has, it's been in discussion since the early part of from 2002, 2003. I know there was a proposal in 2004. It probably was quite radical to start with, as a lot of proposals are, in that it would involve items and things that were not already in existence, and the transfer of DNA and things like that, quite controversial areas. And now obviously it's been narrowed down in terms of what it could potentially offer. Now, just going to see if I can. Oh yeah. So I suppose we're talking about mutual recognition, and the reason I just went on a little bit about the European Arrest Warrant is, in my opinion, the European Arrest Warrant is really the first substantial bread and butter instrument that tries to overcome in the whole question of judicial cooperation in the criminal field. How can we bring in an efficient system? Obviously the Advisory Council of 1999 is identified, I suppose, the first the start of the roadmap in terms of this idea of mutual recognition. And there's different views about how effective mutual recognition is, and for a number of years, certainly up to now, it's been going in a certain direction. There are a number of instruments that are either about to come in or are there, I suppose, in terms of freezing of assets, things like that, that are already in place. But the question is mutual recognition, as we've experienced it for the last number of years, is it sufficiently robust enough? Because, of course, some would argue that really the only solution is you would have to have a kind of a corpus juris, that you would have to have much more change in the substantial law of the member states. But, of course, that's a very, very revolutionary concept. But then others argue, and I was at a conference there very recently by the Royal Academy, and Professor Dermot Walsh, he's talking about an emerging legal process that even pre-Lisbon, even just the way things are going, that effectively, because of the way mutual recognition works, and that you have 32 types of offences, and that we all have to agree what these types of offences are, that we are already changing radically, our substantial criminal law, and that it's happening by osmosis, so to speak. And then, of course, he's referring to organisations like our own and Europol on the police side, that already, along with some changes in terms of with Europol, with their new decision, which has just been published recently, and for Eurojust there will be a new decision which is being published, which will take effect later this summer. Things like being able to call on the member state to initiate a prosecution, and if they are not willing to do so, that reasons would have to be given. So there's a lot of there is potential there. Up to now, certainly the experience, certainly from my perspective, is we tend to take some would say maybe too passive an approach, but certainly in terms of things like conflicts of jurisdiction, we would always try and get consensus among in terms of if there's two or three, we would try and get consensus. We wouldn't be attempting to actively assert our personality as a unit. And there's arguments pro and con that approach. Okay. As I say, you could just see the list of the types of things that are going to be included in this. I mean, the idea would be that, even though some would argue it's taken several years for us to have the 2000 Convention, which allows things like spontaneous contacts, in terms of monitoring bank accounts, a whole lot of new, the whole question of video link, various other types of remedies in terms of cooperation that were heretofore. What we really had was the 1959 Convention. It has brought us into the modern world. Now, with this, the idea would be that come 2011, that all of these existing mutual assistance, obviously, when the European Evidence Warrant takes effect, you will have a whole plethora of other mutual legal assistance instruments in place. But the ultimate idea would be that by, I think, 2014, that the European Evidence Warrant would be like an all-encompassing package of a method of transfer of evidence. Now, as I say, you'll see there's a number of exclusions at this stage, including things like forensic samples from the body. You'll see also excluded real-time evidence, electronic interception of communications, notwithstanding the fact that in our mutual legal assistance legislation and with quite recent legislation in terms of in this area, that maybe we're actually going ahead some of these exclusions already. And I've no doubt that this will be looked at again, and that there would be pressure on for some of these exclusions to be taken off. It's interesting too, I should say, that in the European Evidence Warrant, Germany, for example, have a very strong declaration where there's, I think, about 5 different types of offences that are in this list of common offences, where they would reserve the right to interpret as to whether or not in fact, they would have to assess whether, in fact, this was really substantively a criminal law in accordance with their criminal code. So, I mean, obviously, I think this reflects the consensus that was arrived at certainly by December of last year. I mean, I suppose the question, why the necessity for this type of package going along with the whole European Arrest Warrant. And I mean, I suppose the constant refrain from practitioners in all member states is to try and speed up the process. However, on the other hand, one could question whether the European Evidence Warrant, initially at least, will really be so revolutionary if it does not really attempt to change the substantive law in member states concerning the admissibility of evidence. It's one thing to agree on common offences, on time periods. I mean, I think there's a period of 30 days, reflecting like the European Arrest Warrant, and another 30 days. But as we know, for example, with the European Arrest Warrant in this country, if a requesting state in a difficult case, if they are expecting that there would be a surrender within 60 days or even 90 days, it's probably it's not a realistic expectation. And in fairness, that happens in other member states as well, due to quite legitimate challenge on various points concerning the request in the requesting state or in the requested state. But as I say, there is an emphasis on the whole question of acceleration. Obviously, the sensitive issue is in Tampere, certainly, I think, and I do remember hearing at a conference last year, one of the persons that was involved in that from the Finnish government, a legal advisor, they were very enamoured with the concept of direct enforcement. In other words, that all of the power would lie in the requesting state. But, I mean, clearly, if you don't have any mediation, if you don't have any supervision of coercive measures in particular, such as searches and the taking of items in searches, if you don't have some supervision of that in the requested state, I think just from a sheer, not even just a political, just even from the point of view of the person on the street, the ordinary public, I think they would have concerns, for grave concerns about that. And that has to be realistically taken into account as well. The grounds of refusal, there is a list of grounds that they are, as I say, they're limited, where there is issues such as where the act under investigation in a requested member state is in crime. That's straightforward enough. Offences in the requesting state must be punishable within a 3-year period. And as I say, then they have the types of offences where double criminality wouldn't be applicable. There's similar to the European Arrest Warrant. You have a list of 32 offences. There is a reference, I see, in Article 13 to a territorial clause. Again, I think, I'm not sure which member state really insisted upon this in the negotiations, but that maybe it was Germany, I can't be certain on this, but where a requested member state doesn't recognise a request, if that state considers that part of the crime, or maybe all of the substantive crime, actually happened in their territory. I know one country that's always very worried about a lot of these measures is the Netherlands, because there's a huge drug trafficking problem, and it's not just the Netherlands itself as a domestic entity, but also there's an awful lot of international drug trafficking, and there is a resource question, and there is a great fear always. I think certainly not just at the Ministry of Justice level, but even in terms of the prosecution service and at the police service level, that unless they have some way of mediating this, that they don't want to have a situation where they're flooded by requests from requested states where they have to do something. They don't have any choice in terms of whether they have to implement a request or not. And certainly that's an issue. Safeguards. Obviously the authority issuing the European Arrest Warrant, limited. Obviously it's quite a broad number of actors, but they are all, I suppose, coming in terms of the judicial authority or judicial personality. Judges, investigating magistrates, public prosecutors. Now, some might say that that's not maybe enough, that depending on which jurisdiction you're speaking of, a juge d'instruction in France or an investigating magistrate in Belgium could have very substantial powers in terms of but going back to the whole mutual trust thing, that it must be proportionate what they're requesting, as opposed to if an application is done before a court, a judge sitting in court. And of course, it must be obtainable in their own member state. At least that's the objective stated. Other grounds for refusal, immunities and privileges. Of course, that's not uncommon under the law of the executing state. Article 11. This obligation. The executing authority shall recognise a European evidence warrant. That there is an obligation. Just a little bit very quickly about implementation period. I suppose the first key date is January 2011. There will be a provision also for review. It's built into the instrument. There will be a review, which will involve the Commission carrying out, the Council carrying out an audit of how it is working. And I have no doubt as well that they probably will set up, similar to the European Arrest Warrant, a sort of a peer review system. And in that regard, I think it's interesting to see how that's working. The European Arrest Warrant now has been evaluated, its operation to date has been evaluated in all the member states. And there was a final report on the fourth round of mutual evaluations in April of this year. And there are a number of recommendations in that about improvements. Some of them, as I say, they're quite common or Gardner things about language translation issues. But there are some general issues that are common to a number of member states, and one of them was the necessity raised by several member states to take further steps to approximate legislation and identify common procedural standards as a way of enhancing mutual trust. Now, it doesn't say in the report, identify specifically which of those member states are sort of that view. There's always a tension there, and I mean, I know myself that, for example, a very recent instrument that has just really been almost completed by the Czech presidency is the whole question of conflict of jurisdiction, and it certainly was one of the ambitions of the Czech presidency that they would settle upon a workable instrument that would make conflicts of jurisdiction where you might have, say, between 2 or 3 countries, you would have a genuine dispute as to where the proper place for where the jurisdiction lies, and that up to now, where it's done on where it's very much on a state-to-state informal basis, that there would be some more objective way of being where there was a logjam for something to be done. It's interesting. I was at one of those working party meetings, and certainly I think the Czechs were not ready and it's maybe ironic it's the Czech Republic, but I don't think they were ready to anticipate that there was an awful lot of scepticism. And I hasten to add, it wasn't coming from Ireland, but from, as I say, the Netherlands, Germany, several other countries who had, big and small, who, again, on the issue of resource capacity, and there's always great concern among ministries of justice, but also, I think, reflecting what they understand their practitioners' concerns are, that there isn't an overload of the system. That if something is working, or if there is no apparent huge problem with conflicts of jurisdiction, we don't want to create a huge bureaucracy for this. So reflected in that then has been a much more diluted system whereby effectively member states, the prosecuting authorities of member states, they can notify the states that they have an issue with. There is a possibility of referring, for example, issues to Eurojust, but there is going to be no compulsion. It'll be effectively a non-mandatory. It's not a mandatory system. And similarly here, I think that some of these kinds of mutual recognition issues could come up with the evidence warrant, practical problems. Again, in the European Arrest Warrant, the whole problem of double jeopardy and ne bis in idem. And then, of course, there's also an issue in terms of, for example, where you have requests for additional offences to be prosecuted. A person is surrendered, particularly large member states. They they make a request for somebody on respect of one or two offences, but it comes to light that in fact that person is requested for a number of other offences at the time that the European Arrest Warrant was granted to that requesting state, and then there is a process for them to ask for consent to prosecute for these additional offences, and that can cause problems on both sides. And I again, these kinds of issues in the context of transfer of evidence, it could be an indication of the types of issues that might come up. Another, I've mentioned about this whole issue of common procedural standards, as well as the substantive law. As I say, the EAW, it was the first instrument in the field of criminal law implementing the principle of mutual recognition. Of course, as I say, you have a number of other ones. You have the freezing and probability of evidence, 2003. You have the whole question now of criminal records, which is coming downstream. It's quite a very complex project, the whole question of exchange of criminal records. But I think it's a very fundamental, practical issue that needs to be. That I think it's an issue in many member states where you have somebody who is before a court, and the traditional method of perhaps using Interpol to get records, criminal record in terms of convictions. You have a person perhaps facing the court for sentencing purposes for very serious sexual crime or other serious violent crime. The idea that you have to have a bureaucratic system which could take weeks, if not months, maybe even theoretically, which wouldn't be realistic for the sentencing court to get that information, that's a challenge. Whereas, as I understand it, there's a lot of work now going into the whole question of sharing national databases of convictions. It's not an easy project, it's quite challenging, but having said that, they have already developed a lot of experience with the Schengen system and with Schengen 2, which we will be coming on stream with as well. So I think one cannot necessarily utilise the excuse of the lack of technological solutions. Of course, there has to be supervision of these things. There has to be trust that these, as I say, if you're sharing criminal records, that there's integrity in the system. But I think if we're here in 2010, 12, 13 onwards, it could be that if the time on which an investigating officer, police with serious crime, if they can get evidence transferred within a period of, within say 90 days, for example, realistically, that certainly could be a way forward in the current patchy situation where in some cases, especially complex cases which involve the whole question of maybe surveillance evidence. Now, some of the evidence that might be requested here may not be permissible in the first phase, so to speak, of the European Arrest Warrant. But I mean, I suppose certainly, and I think it's opposite in terms of what we've been discussing in recent weeks in terms of the legislation, in terms of serious organised crime, and the whole question of being able to utilise the evidence of surveillance, and particularly wiretapping evidence of conversations that are made by criminals themselves in person. The possibility, perhaps within the next number of years, that type of evidence can be at least readily transferred, and that the time scale for which objections could be made in our jurisdiction will be time limited. That could be very useful, because the reality is, certainly, I can say certainly for sure with the Netherlands and Belgium and Germany, they are already quite advanced in this field, and they are supervised. There is judicial supervision. Of course, their public prosecutors have quite a distinct role in those jurisdictions in terms of ensuring that such measures are being authorised in a proportionate way, and the evidence. But the collection of the evidence, it's done much more quickly. There's much less uncertainty about that admissibility of such evidence within their court systems. Now, of course, there's differences. I mean, there's substantial differences, say, between the German criminal system and the French criminal system. But I think a very good example of the way of the future is there's what we would describe as a mini Eurojust in Maastricht, where, again, it's because of the accident of geography, but basically you've got within a space of 200 kilometres, you have a number of jurisdictions. So essentially you have a group of, quite a small group of police officers and magistrates and prosecutors working together in Maastricht. And I mean, they have gone much further than what's ever been contemplated here with the European Evidence Warrant. They can transfer DNA data. They can first of all, they can exchange that information, including, as I say, DNA database details. But also, there is no more the formality in respect of the admissibility. I mean, this is the real issue. The admissibility of the evidence that's collected and that's exchanged by these three jurisdictions in that particular project or that particular system there is the minimum of formality. Now, of course, it develops on trust, and neighbouring jurisdictions probably trust that have the best possibility of trust because they understand their systems, they work together, and I mean that's commonplace right across Europe. You know, Slovakians, Czechs, Polish, they will all understand the German system far more readily because there's so much interaction there, and similarly with neighbouring countries around France. But notwithstanding that, certainly, I think, of course, you have to have you have to respect in terms of the relevant human rights requisites, but there's a balance here, there's proportionality here. But I think if the European Evidence Warrant is the way it's foreseen, if its real added value will only be if it will reduce the difficulty of the admissibility of such evidence once the process has been gone through in terms of the order that's made by the judicial authority in the requesting state, and then if it's a coercive measure in this phase, that the permission is given for the coercive measure, but that process takes a relatively short period of time, as opposed to having the possibility in the current scenario where you might literally not be sure until the trial starts, and then you're having a trial within a trial. And obviously for some of our civil law practitioners, that's quite they find that quite difficult to understand why it can take so much time, and that we don't know literally until the trial maybe commencing, whether in fact evidence that's been taking quite a lot of effort to collect from these other jurisdictions to be able to admit them into the trial in Ireland. But of course, these are not simple issues, and as I say, I think one has to really always be conscious of the question of mutual trust and recognition. But we've got to remember, if we don't follow the mutual recognition route, if we don't try and really get the full benefit of that, then you're looking at a much more radical system of, as I say, which was the Green Paper, for example, with the European Public Prosecutor project back in 1999-2000. This kind of idea of corpus juris, that we've got to basically have a code Napoleon, and I think in the current environment politically in many countries that probably would be unacceptable. I mean, it's not really just a common law, civil law argument. There are many practitioners in terms of prosecutors on the ground in these civil law jurisdictions who would have concerns about some sort of uniform code. So that's why I think the mutual recognition approach, it has to be fully utilised. But we are coming to a tipping point, and the European Arrest Warrant has given us good and bad examples, but it's shown us the problems, and unless they are overcome in terms of, as I say, utilising mutual evaluation, even the necessity, if necessary, that member states are going to have to, as they say euphemistically, approximate their laws in certain areas in the operation of, say, the European Evidence Warrant, it's not going to work. I'm quite happy if people want to have a copy. I haven't gone into huge details about the European Evidence Warrant because I think really it's more of what I would like is if people have, it's to try and give some pause for thought that people have about it, because we've got to remember, in terms of, I asked my contacts in terms of Brussels, in terms of the unit in the Commission that deals with this, there's actually nothing active happening at the moment in terms of insisting upon, evaluating what have you been doing in your member state to implement this. I get the impression as well that they are, dare I say, people are lying low to some extent. They realise there's a tsunami of other existing instruments that need bedding down in implementation, and that, for example, the Swedish presidency, I mean, what their focus will be on transfer of proceedings will be one of their points. So it's there. The document is complete in that sense, but I can imagine going into the latter part of 2010, 2011, it's going to become much more of an issue and focus. And I can see defence lawyers then will become interested in it, and they will have issues. Now I know, for example, the European, I think it's the European defence lawyers. There's a UK. European defence or European criminal law group, and I know they've already been looking at it, and they do have concerns. And I suppose one big concern for defence lawyers is, well, what resources do I have if a decision is being made in another state, in terms of my input, what legal aid is available? And of course we know that there's been huge discussion and debate about even common procedural standards, safeguards. Again, an issue that I think the Swedish presidency are maybe trying to finalise upon. So that's, as I say, just my general overview.
Thank you very much indeed, Jarlath.